Yes, please.
Special officer who work in the matter relating to the roads.
Mhm.
We have been, special officers have been informed that there is some situation with regard to the road during the Blair town where underground cables are being laid. But the way it has been done has caused severe damage because there are massive holes which are left on the side of every road, and which is there all over Blair. We have seen for ourselves. In front of the High Court also, there are two such places.
Oh,
So now this needs some urgent attention because there have been a number of accidents in the last 2 weeks and the situation is not being rectified. We had been hoping that it would be.
you will be appearing.
It's concerns the epidemic. So I will inform Mr. Sharma for the NH as well. If the matter can appear any day during the week, let Mr. Chakraborty take instruction.
That will be better since he is mentioning it's not adversarial. You find out what is the situation and how soon you can remedy it. We'll keep it on Wednesday. You inform the NHI person also.
I'll-
List it on Wednesday.
Item number on.
Lord, I am for the petitioner.
This one.
Contempt petition cap has extended, granted more time.
Oh, yes.
Lord,
How can it be indefinitely?
for the last 4 months, they are not doing it.
Sought instructions.
Positive.
Yes, in fact, if it can be passed to what I've asked to, the written instruction is just on its way. If my lord can pass it over, my lord can hand over the. It is being done, they are.
No, we'll rely on what you say. You tell us.
The instruction that I received with my lord has been approved by Administrative Vigilance, Personnel Law and Finance Department. Now, my lord, it is before the Chief Secretary, my lord, and one another case, it is before the Secretary R.D. Panchayat, which is the competent authority. And my lord, it is for confirmation, so my lord, only my lord, 10 days it will be done.
No.
So, but it is in the final stage, only that.
See, that is there is no change. This is what we were informed on the last day also.
So your lordship took the matter, it has been routed through the administration has given.
Why the chief secretary will take 10 days for this? What mind apply? You have to implement the court's order. So it is all processed and then placed before him. No, it needs to be given due priority. It can't be so casual.
Earlier they had time till end of the month, now they are doing it on
They have time till?
terms of the tax order, they are time till 25th.
No, 20th December already expired.
No, extended till January, but in view of your lordship's indication, they are expediting.
In my contempt application, extension was allowed, my lord. That is the reason I filed this.
You need to argue.
My lord?
You need to argue.
No.
This is a contempt. It's between the court and him.
No, this is not contempt is in.
It is a contempt, sir. Essentially, it is a contempt. Order arising out of contempt. You have nothing to say.
I have to assist my lord.
No, you not. Only when we ask you.
My lord may record that you done in 1 week.
No, come back on Friday. Please impress upon the authority. We will not take it like this. You come back on Friday. Expedite it. Why? What is this? 3-4 days that they're still pending in this week, remaining in this week. You need 10 days for this. Show some diligence to compliance of the court's order.
Your Monday, then tomorrow is holiday of the administration because of.
Friday 3 p.m. Friday 2 p.m. You find out on prayer made by learned senior counsel. Well, both together.
Yes.
Oh, so Chief Secretary in the first and second.
Chief Secretary is second,
Okay, before the
Blair.
The WPA 11/24.
My lord, in my senior submission, service appearing for the petition, my lord. On the last occasion, my lord, the respondent of Union of India is directed to file the reply, my lord. Report, my lord. So report, the copy was still served, my lord. Date may be given for.
let us see what is the report, what is the PIL.
Yeah.
What is the issue in this PIL?
The 50 megawatt generator should be established. And that has been done.
So where is there was a direction?
The TILS file saying that there are power cuts, my lord. So one of the things which administration filed its report, and then administration also pointed out that this is also under process. So the petitioner's counsel said that the administration has been pursuing this matter with the ministry. And the ministry is to intimate the status of this project. So my lord, the ministry has now filed a report saying that LIT has been.
Oh,
There in terms of there D.
what is LNG? Liquefied natural gas. So this generator operates on LNG.
So this shift from diesel to.
Oh, so it's not to augment the power supply, it is to change the both. Both things are there. No, what is the scope of the PL that we are trying to understand? To enhance the generation or just to make it eco-friendly?
To enhance the generation, but it believes that this will result in.
Because if
There D.
no, Prayer G says, so prior to this PIL being filed, the generation was below 50 kV. Below 50 MW is to augment.
That's why prayer D is independent of prayer C.
Hmm.
The same there are several power cuts, etc. And why is this disruption happening? That is one of the issues.
No, another aspect which we are trying to understand is Prayer D says LNG. So prior to filing of this PIL, the generation is through a generator which is being operated on diesel. So this, when you say that something has been approved, it is approved in the LNG fuel kind of a diesel. So this is for the gap between the present generation and augmented generation, or all of it will be now through LNG.
This will be in addition.
So why can't the existing diesels be also be operated on LNG?
Which will be added.
No, see, we are all here for the betterment of the environment here also. So therefore,
Yes.
we are not giving any directions. We are just expressing our mind that since now you are going to eco-friendly mode, this island, so such precious forest resources are there and the environment is so nice. So if, of course, we understand that your coffers will permit, whether your coffers permit or not, there are so many things. This transition, how it can be done, all these things have to be examined. But so what is the gap between the current generation and now which you are doing as per the report?
That is not my lord. No, my lord, it is great. We are contending that there are regular power plays. We are saying that it is not a power play, it is interruption because of the nature of the terrain itself. And additionally, the petition has said that we have written to the administration, have written to the ministry for this plan to be set up.
Where is that, right? Where is that communication? No, where is that communication?
Letter from the
Administration to the ministry.
This my lord will see at page number 92 of the PI. In 92, it is a letter dated 2nd July 2024.
So this power plant at Chatham is private? Let's see.
We are informed that we have only one. But the last time it was given.
What does it say? Tell us.
Then by the company submitted in 2018 as per MOM minutes of meeting held on 10 January 2018. Honorable Minister of Power and New and Renewable Energy directed NTPC to establish a 50 megawatt LNG power plant with a long-term power solution. UP administration designed the entire power demand and supply chain based on this LNG power plant. However, during the meeting held by Honorable Minister of Power NRE on 25th May 2023, 50 megawatt LNG power plant, our power project was set aside due to financial non-viability.
Okay,
Unanticipated decision has disrupted our long-term power availability plans and severely compromised our capacity to meet the growing power demand. Therefore, this administration, with a DO dated 9th August 2024, requested ministry to revisit the proposal of 50 megawatt LNG power plant as under GNI mega project. NTPC has already been engaged for setting up an LNG-based power plant under proposed energy mix proposal. In the matter, Lieutenant Governor requested the Honorable 15th October 2024, requested the Honorable Minister of Power will consider the proposal of 50 megawatt LNG power plant towards a step to clean energy to ensure dieselization and cleaning of oil. So after this, now the report has been filed by the ministry informing that they are going ahead with that.
so it is probably doing away with the diesel thing. The last part that you read,
First step. Because after the Greater Nicobar project comes into being, my lord, the requirement will also increase manifold.
no, plus all of this is being done pending the transmission of electricity from the mainland, which is expected in 30. We have since from 2030. You see from your letter of 2nd July 24. Called, there is some term which you have used. HVDC. The third paragraph at page 1 of 2nd July. More viable option of HVDC link connecting island with mainland, which is expected by 2030. So what is this? This is transmission through some mode from the mainland.
Nation one grid.
Okay, underwater. So therefore, whatever is being done is probably keeping in view this timeline. And for the meantime, then there's not much to be done. That as long as yes. Yes, you give a copy of the report.
Today only I have received.
A report is being filed today.
Item number 4,
And you place your report on record. It's not there.
For our purpose.
2 copies.
One copy is there, man.
No,
Yes, one copy.
there is 1 copy. No, your report.
That is our.
That is the report filed today.
Yeah.
Oh, where is the affidavit?
Affidavit has been filed. Counter affidavit has been filed by the secretary.
Your affidavit is not in court.
We have filed the report. We have read in the registry.
Okay. Let a copy of the affidavit filed. So instead of Union of India, say
number 4, WCT 39 of 2024.
Your Honor, in item number 4, Lokesh Charan sir appearing on behalf of the petitioner, my lord. In item number 4, Lokesh Charan sir is appearing on behalf of the petitioner, my lord. And today they filed the reply, my lord, affidavit and reply. But the copy is not served to the other side. So we have some time, my lord. Yes, yes. I'll
you
give
have
a
to serve.
Yes, yes. But today will serve, my lord. I have already submitted the register.
For you have filed it.
Yes, yes, already filed.
The reply has been filed today.
Yes, yes.
In the registry, let the same be tagged with the records Copy is also served on the.
Not sir, my lord, I have served. my lord.
WPCT 44 of 2024.
My lord, in item number 5, my lord, the Vishal Kumar sir is appearing on behalf of the petitioner, my lord. He is still not recovered, my lord. So let the matter may be posted to the next circuit, my lord.
On account of the, on account of Mr. So and so.
My senior, Mr. Alokis, is appearing for the appellant and Mr. Sumit Kamakar is appearing for the respondent, my lord. Lord, actually, on the last date, this court is directed that they should file affidavit of opposition, but till the date, they have not filed any opposition, my lord. Let it be posted on next.
My senior is appearing on behalf of the state, sir. Due to knee problem, we have gone to mainland, sir. Can it be taken up on the next circuit bench, sir? In the meantime, they will file the opposition.
What happened?
Item number 7. Receipt is 17 of 2024.
My lord, item number 7 was short password, my lord, seek short password.
Not today.
Item number 8. Event is 1661 of 2024.
If my lord, in some embarrassment, I was leading the advocates for the pleaded respondents in the writ petition. The administration has served a notice on me personally to appear. I don't know why. But obviously I'm not one of the party who's put it. This is not.
You were representing them in the
I was
writ
leading
proceedings.
and for some reason they've served me a notice to appear.
So are you, will you be representing or?
Probably have instruction, but first of all, I need my advocate on record. my lord. I need to take that instruction because
No, that we understand. So just thinking of how to expedite, what is the best way to,
probably in all fairness, this would not constitute a good service.
not on that. If you or the council advocate on record has instructions, then we
As of now,
know.
We will serve again.
out of the court, I may say I have contacted them.
My lord, we'll serve again and come back, my lord, in the next circuit. Stay on.
Added, you are for the added respondent.
We had at that point of time in the writ petition been added also.
And the main respondent is represented by you, who was already appearing in the writ proceeding.
But there, the impleaded respondent's presence is important because, my lord, this is concerning the requirement of islanders card for auto, for giving permission to ply autos. So, my lord, the party which was represented by Mr. Kabir was supporting the measure taken by the administration.
Essentially, there are two sets of unions.
So-
They have one set of unions, we are the other set of unions. But the law and the legal position was always that anyone who wanted to apply for an auto rickshaw permit in the islands in terms of the Motor Vehicles Act and rules had to be an islander. Because the entire scheme that was framed at that time was that unemployed youths who have certain educational
Local.
qualifications but can't get a job, locals would be given these permits. So one of the things that was required when you applied for a permit was your islander card, as Mr. Chakraborty is saying. That portion was challenged before this court. Now, we have been supporting that to the extent that we are the local islander unions. And our livelihood is being challenged because what is happening is people are coming from outside and through names of others or in other ways, they are obtaining auto permits and there's a cartelization which is happening. So we have been opposing this and we have been writing to the administration to stop it. They, on the other hand, have been those who have come in from the outside and say, we have a right to livelihood, why should we not be allowed to? So in this situation, the court took up the matter from a larger perspective, not just on the point of law. There were 4 issues framed. The court considered all 4 issues, and the court has held largely in favor of the administration, except for this one thing with regard to the islander requirement, by saying that the law never originally required it. So whether you, by way of a circular or a notification or a guideline, could add that requirement to your application criteria. This is the issue on which probably the administration has now come.
The act would fall under which list?
Now, technically speaking, this is in the 3rd list, but the issue is not of that. The issue is if what I remember of the matter, I'm just trying to assess about. Under the Motor Vehicles Act and the Motor Vehicles Rules and the Central Motor Vehicle Rules, it is permissible for the local state transport authority or STA to come up with necessary criteria that they feel is appropriate. The only problem is that must then be brought through a legislative medium. Now, in the Andaman and Nicobar Islands, you have the state transport authority where decisions are taken, but those decisions are notified as circulars or bylaws of the state transport authority itself. Now, under the Andaman's regulations, that is permissible. But if one looks at it in the stricto sensu legislative perspective of the act.
That's why we said which list. It is a list 3 legislation
Yes.
that we all know. Therefore, we
So
put this query to you.
yes, so the issue here is that now the competency of the state transport authority to take those decisions is not doubted. The fact that they frame such bylaws is not doubted. But it has not been perhaps notified in accordance with law.
That makes all the difference.
That makes all the difference. So
258 will come into
So
play.
then it comes down to a matter of interpretation of the rules. Even if I sever the bylaws and I keep only the rules, even there within the rules, it is implicit that the local authorities can implement certain controls. Then the question becomes, does this fall within a control or can this be read in such a way that it abridges their right to livelihood? So it comes down to that sort of an analysis.
Because one of the grounds on which the learned single judge has held in our favor on the other aspects, for example, my lord, there was another requirement that the person who applies for the permit must be driving the auto. So that has been upheld.
That should be, I mean, then otherwise the whole thing gets stated.
Yes.
That is where the cartelization is happening.
No, that has also been done. That has also been done by the State Transport Authority through its minutes. But that issue court has held in our favor because the honorable
So
court.
what has gone against you?
What has gone against us is islander card requirement.
Can we see that? Just where is that? In which part of the order? None of you are having the brief.
My lord, I am fortunately.
Okay, we have seen it is small Roman 3 at page 25. Not within statutory contemplation. That is what the court has held. So what will be the effect? The effect will be that anyone can apply for.
Two things indirectly will happen. Number one is that any person who is not an islander can come in here, order an auto rickshaw, obtain a permit, take delivery of the auto rickshaw and fly it, which violates the original schemes framed by the administration that this would only be for local unemployed people.
So therefore, what is crossing our mind is how the conclusion, whether it can be
That is dealt with.
read together or it gives rise to a dichotomic situation.
It does, because some of the other findings in the judgment, let us say for example, the cartelization I spoke about, this is where people who have some money who come in from the mainland, they buy up say 10 autos. Now they fly it through some individual persons. However, those 10 individual persons are not the owner, operator, permit holder of that auto. So allowing this will actually militate against the other findings of the court, which have upheld the policies of the administration. So that paradox needs to be resolved to that extent.
This paragraph 22 onwards is the decision on this aspect, but requires some hearing.
Yes.
If my lord sees paragraph 59 just for a moment. Now, Roman 1, the second line. The notices issued with regard to the transfer of permits or against the persons who are otherwise unauthorized to drive the auto rickshaw is because the police has been taking out a drive against people who are driving it, who are not the owner or permit holder. This also has ramifications in terms of insurance, in terms of motor accident claim liabilities, because the person who is actually authorized and having the permit does not have the necessary liabilities in terms of law. Then in addition to that, the second clause is that there's no scope for interference.
That is the clause which stands out
Exactly, but the difficulty is that if one is to read that
with clause 4,
number 3 and 4,
3 and 4,
it
yes.
cannot be harmonized. They
So-
either stand together or fall together with respect.
Because the other decisions are also brought into force through the minutes.
Same.
Through the minutes. Now,
This is
whether
the
it was
system of
initially part,
So if it is not sustainable, it is not sustainable.
That all goes or all stays.
no, there is a slide to sustain what has been upheld by the, what has
It's
been.
under a statutory provision.
There is a no, as far as the statutory provision is concerned, both sail together, but the another distinguishing feature which the learned single judge has held while holding in our favor on the other condition is to say that that was part of the original terms of the permit. So the learned single judge says that in the original term of the permit, it was specifically provided that only the person who is driving the auto will be the permit holder. So the learned single judge says this, the other condition of islander was not there in the original permit terms. So you have added it in subsequently by way of a minutes of meeting. So that will perhaps, in case we are not succeeding in an appeal to sustain the order of the learned single judge, we would make that sufficient. Although it has not been challenged, nobody has, we have only challenged the others, the petitioner has not challenged the order.
No, because otherwise it does not offend them.
Yes.
All that is required is that they have to operate it themselves. They cannot run a business, but they can run a auto rickshaw.
But that was happening. Why the STA acted is because we found out on investigation that the payments, etc., were being made, they were linked to the same mobile number.
Oh.
So there was one or two few individuals who were actually facilitating of obtaining of permits by a large number of other individuals.
Having a fleet.
Yes, having a fleet effectively, and it was being applied in the names of different persons, but the payment source was traced to the same individual.
And our concern is the fleet and operation thereof is detrimental to our interests.
That we have understood.
So that was our
Serve a copy.
You serve and my lord.
Done.
No, my lord, it will take some time. Not be fair to the honorable bench.
deep.
Interesting. I would have decided if it was complete.
Image 70 of 2024.
In this case, also, my lord, same advocate is there, my lord. Is
Indisposed.
also, my lord, same advocate is there.
Indisposed, next circuit.
Item number 10. CPN on of 2025.
Lord, I am for the petitioner. It's contempt application, my lord. My lord, yes. It will be placed before the Honorable Justice Rajshav Manta and Parthasai this evening. Order is at page 7. The operative portion is page 9, my lord, para 30.
The system, it has to be placed before that bench only.
My lord,
Then there's no point in seeing it.
no, registry may be directed to,
We need not see the order.
yes,
That is the way it is done in all the contempt.
yes, yes.
The contempt is alleged.
Item number 2, sorry, item number 11, CPN 2 of 2025.
My lord, same advocate is there, my lord. Here in this
Same.
case, yes, my lord.
Honorable judges are.
So this is the system. This is how it is done. And no, that for assignment, Chief Justice's order is also not required.
Says subject to. There's a standing order. For review, modification, contempt. And one more, there is a standing notification that if any of the members of the original bench is available, it would be placed there without assignation. Then in between, we had the situation where we had to make a prayer for assignation to the Honorable Chief Justice and then it would be assigned. But that was also cumbersome. So now we have a new system where there is a separate bench created whose determination is to take up any matters where the existing bench was not there. So assignation is
But
not.
there is one honorable judge is there, then it has one form.
One.
It has to be
So
followed.
here both are still,
Here the division bench is available.
So if any of the judges of that bench are still available at the principal bench, Manoj, then assignation is.
Single judge has limited. That, but the division bench.
so now it is the order of the division bench which is to be complied.
Upon the order. Now, division bench is available.
In both the orders, same, registry to take appropriate steps.
Proceeding 234 of 2019.
Yeah, this for the respondent, we have received the proper information. If the matter be approached to make circuit, it's not available in station, we have to make it. This is a personal work.
Let us see.
Okay.
It's on remand.
Yes.
What do you want? But you are not appearing. You are for the respondent. So ask him to appear. It arises out of a decision of the cat.
Yes, madam. And in the decision of this honorable court was challenged in Supreme Court.
That we have seen. The court proceeded on an assumption that it is the same same proceedings, but the Supreme Court has found that no, it is otherwise. So therefore, it required consideration. So there are two proceedings against him, one arising out of criminal case and
Yes.
one under 311(2) you have passed the order,
Yes.
dispensing with the inquiry.
Yes.
It is submitted by MS so and so.
Item number 13, affirmative WT1 of 2024, with item number 1415.
He is met with an accident.
Out of an order passed by the Labor Commissioner under the Workman's Compensation Act.
What has he done?
The person, my lord, was a sailor man. He, after being discharged from being discharged from the ship, subsequently passed away. So the question was whether here the NMB agreement, my lord, is involved. Now the question is whether at all jurisdiction could have been exercised by the labor court, but that argument we cannot put forth because when they had filed a writ initially, it was our submission itself that he should go to the labor court.
So what parties
Labor
cannot mutually confer jurisdiction even if it is.
That is one part. The
Yes.
other part is whether, in terms of the NMB agreement, whether the death had occurred, had any relation to his service on the ship. If it was unrelated, then he wouldn't be entitled to the higher compensation. Now, I think this is an appeal under the, initially we had filed a writ. Then my lord court granted us liberty, we preferred this appeal. There's a statutory requirement of deposit, which was made.
Already done.
Already done, and they have got the money also. So first matter is a substantial challenge to the order passed by the Labor Commissioner. Second matter, the second and third matter, my lord, have been filed by the. Perhaps one of those is infructuous because they were seeking the money which they have got. The other is for interest. They are seeking for interest. So, my lord, the execution writ is perhaps infructuous, but the appeal in that item number 14, they are seeking for interest. So that is this Veliammal is the wife of the deceased sailor.
Oh, so all these matters are together.
Yes, ma'am.
Which
It
matter?
has-
13, 14 and 15.
Yes, ma'am. Perhaps if their presence is required, ma'am, but otherwise.
Yes. So this Mr. Peter is in all the matters for the
For M. Veliammal, the private part.
private respondent in
Item number 16, WCCT 2024.
16 minute, I will be appearing for the private respondent. On the previous occasion, I made the submission that he is admitted in the hospital. He suffered a heart attack. We have still not been able to get the Bakaratama signed as per my instruction, he is admitted in the 60. I think the issue.
In between the last date and today,
Circular which I was mentioning, I've just provided a copy.
Oh. Please place it with that case.
Circular, I thought, you know, I'm on the principal bench in 2010. What's happening is all the matters have to be assigned, so it was creating a problem with the files, so this notice came.
No, there is a similar circular operating in the principal seat also. But in the order, normally we say after obtaining orders of Honorable the Chief Justice.
Now that there is a separate bench designated, whenever the judges are not available, it will go there. Earlier, it used to be the bench having the determination. It's in the middle of the page. So it specifically says without further reference for creating another bench.
Ninth March 2010.
Has been clarified thereafter once by circular. It says that there will be a creation of a bench where if both the members are not available, the matters may be set. Now in our appellate side determination, it comes out.
Any matter as
This is what we are following to do. The principal bench is ready.
No, but this doesn't say unless you are referring to someone else, some other notice.
In the middle, that if any matter arising out of contempt, review, clarification, recall, modification. If
If
either
one of the member is not available.
one is not available, put the bench where the other member is not available.
Yes.
If both are not available, then it will revert to the bench having determination. So that is why what happens in matters arising out of court level. If either are not available at the principal bench, then the bench sitting here has determination in your sitting.
No, but the order therefore, I don't know.
So the usual order is that since one of the judges who passed the original order is available.
Speaking for myself, I have never passed an order even though we know that the judges are still available, directly listing it. We always say after seeking appropriate orders of Honorable the Chief
I
Justice.
understand. Which is why your lordship should not say that it has been listed. Your lordship should only direct the registrar to take appropriate steps.
Therefore, we have set up yes, appropriate steps. Yes.
I'm sorry, ma'am, that was just to.
No, thank you. Yes. Proceed.
Any not in the race? Item number one. WPF 507 of 2024.
I pray for respondent, my lord. I pray for not today.
Why?
Your copy of AO is
Copy of?
opposition has been taken. I will collect it from the department.
Copy of opposition?
I pray for only not today, my lord.
All right. Not.
Six 34 of 2024.
Seeking extraction of time, my lord, to file opposition.
And for the petitioner, till time expired, that's why I mentioned the matter. It will be extended.
2 weeks, my lord, may be granted.
In this, it has already been, the restaurant operation has already been stopped, something like that.
Yes,
That
yes.
one.
Yes, ma'am.
It was taken up earlier on some day. How you will file your opposition this week?
2 weeks, my lord.
For the 2 weeks is allowed for filing affidavit in opposition. Matter.
Item number three.
This, my lord,
WPF 7
appearing,
of 2024.
matter is appearing for the first time, my lord. I'm seeking time to file opposition.
What is it? Rate
Interest
appeal.
on the delayed payment of pension.
To see, what is the order? The Honorable Single Judge's order?
No, my lord, this is, order is at page 44, my lord. Order passed by the authority.
Page 44.
44. आप कुछ brief नहीं है?
So that order has been challenged before a division. Oh,
This.
Yes, Your Lordship. Pension was not paid, so that order was challenged before this honorable court, the division manager, up to Supreme Court. And after much time, they have released the amount.
so what was the order passed in the earlier litigation?
That is also there. Just before that. 27,
Page number 27.
single judge order.
So what is the delay? How much delay?
Your Lordship, he was supposed to get it on 31st July 2023. He got it on 14th June 2024. Approximately 1 year. You can take it as 11 months.
And you had in the writ petition, did you make a prayer for interest?
No, Your Lordship.
No, that issue is also there.
I filed the writ application. This is a second round. First round.
Obviously, so therefore I'm asking you.
No, for interest also, this is the second round. First round, I filed an application. This honorable court directed the authority to consider my representation and dispose it on. And then they rejected it, saying that there is no delay.
So where is the original order passed by on the writ petition filed aggrieved by dispersal of the pensionary benefits to you? Which is the order passed in the first writ petition?
Page number 27.
26 September 23.
Yes.
And where is the writ passed when you approached for grant of interest? Order passed?
43.
After disbursal of the principal of.
First, the presentation.
ये आपको प्रिंसिपल मिलने के बाद ये ऑर्डर पास हुआ.
बताइए
ये ऑर्डर है ना.
So there's some provisional pension was being paid to you.
Provisional pension was.
Provisional pension was how much?
Monthly pension was.
How much?
Much I have to see.
There are rules which say 50%, after 1 or 2 months, it goes to 75. In some rules, the provisional pension is also 100%. So what is the quantum which has been paid to you as provisional pension? That would be relevant. If by way of provisional pension, you are getting a substantial amount, then where is the question of,
No, retirement benefits have not been given to, it has not been released. That 35 lakhs something, that has not been released. Provisional pension, yes, it was later released.
so what other benefits?
That is gratuity, leave encashment, all those. All those have been released only on 14th June. Those were withheld by the authorities.
But how an interest issue can be gone to in a writ proceeding?
Your Lordship, I have certain decisions, I will place it, let it be fixed day after tomorrow, because I thought that they will be filing affidavit with opposition. So I will place it.
Let us see first. Otherwise, keeping it pending only to relegate civil remedies is pointless. If you want a quantification of or fixing of interest, how it can be done in a writ proceeding?
It's authorities, but I'm entitled to interest if that is held, that is enough.
What interest?
Interest upon the delayed payment of retirement.
What interest? Once a court comes to a conclusion that an interest is to be awarded, the court would be required to quantify the interest. It can't be an interest in air. So therefore, I am observing or I'm asking you to assist on this point, whether it can be done in a writ proceeding or quantification is required to be gone into inappropriate civil proceedings. Day after, I have spread list on, give the date of Thursday.
But for, the service is incomplete, Your Lordship, item number 4 and 5.
Service incomplete.
Not
In which one? 4.
4 services.
All right, come. In 4, what is the last order? There is some order. No, but let us see the order. Last date was adjourned because someone was indisposed. Number 4. Yes. What is the order impugned? So against an injunction order, you have filed a revision.
No, Your Lordship, for the TV disposal. That's the-
You are challenging the order passed in on an injunction application under order 39 by way of a revision.
But I have not challenged that order.
You come to your prayer A at page 6. Oh, that is the ground. Where is the prayer?
I have challenged the order dated 3rd December 2022.
3rd December. What is the order of 3rd December 2024?
Adjourning the matter, Your Lordship. I have challenged the adjournment granted to the, granted by me. I am praying for a speedy disposal of this matter. A time bound direction is required.
Where is the order of 3rd December, madam? And what happened after 3rd December 24? It has been fixed on 24 too. For framing of issues.
24th February.
Yes, so what is this? You go and appear.
Your Lordship, they have been taking the adjournment since the beginning and the court was allowing the adjournment. That's what I wanted to show. And we see the, just a preceding order.
Yes.
Page number 55. After obtaining injunction order,
The order of injunction is dated
which is dated 25th. Yes, 25th, 16th January 2024.
24. Yes.
Page number 51.
Yes.
The order and thereafter they have been 6 times.
16/1/24. How many dates have been fixed after 16/1?
16 or 25/4. They have first of all.
25/4.
Yes, they have suppressed the fact that already injunction application was heard and rejected. And then I had to file an application to remind the court that injunction order was already passed against the plaintiff.
So 25/4 was adjourned because you had filed an application under whatever it is on your application, 25/4.
Yes, it was very.
And then
Temporary injunction was very.
Then what is the date?
Then they have taken again adjournment on 20th August. Page number 55.
20th August.
Yes.
Right. Then on it was adjourned to 24th.
3rd December.
3rd December.
August, December.
There is nothing, no informative.
I am just saying, Your Lordship, that preferably within a period of 1 year.
Cannot be. You have to see the Supreme Court's latest judgment on this aspect. Yes. Third Planet Council for the revisionist. The
Item number 5, CO 16 of 2024.
In item 5, I am appearing for OP number 1 and 2. There are 3 opposite parties.
yes.
I am appearing for 1 and 2.
Oh, the one is still unrepresented. What is the, let's see the order, what is the prayer?
In 25 the suit, decree of partition was granted in respect of certain properties, matter went up to the Honorable High Court, and there was certain modification in the decree.
Sorry, can you please repeat this?
The plaintiff filed a suit for partition. For certain properties, partition was granted. The matter went up to the Honorable High Court in second appeal, and there was certain modification to the decree. Now, everything finished, Your Lordship. The final decree was preliminary, decree was passed. Now the question was for final decree. I filed an application under 26 Rule 13 and order 26 Rule 18 before the learned court below for appointment of partition commissioner and for also for the final decree. Now, Your Lordship, those applications were pending and the court below was searching for the file. The file was missing. It was my luck that all the certified copies were there with me. I filed the certified copy before the learned court below and requested the learned court below to take appropriate steps for reconstruction of the file. It's pending since, I think, more than 3 to 4 years. Issue is pending only with regard to reconstruction of file. I filed it. 28th April 2021. It started Vinesh.
Like prior to that, I want to submit something.
No, just wait. what happened on 11/11?
Copy is not there. Doesn't matter. 75 is my application, 75 is not.
No, but how do we know? Come with it. Come with it. Yes, as paid. Learned Council for the Revisionists, as paid by Learned Council.
Six, WPA data 125.
Let us see what is the issue. Service, whether. So none appears today. None appears. Matter stands adjourned for the day. Tomorrow.
Number 7, T20 of 2024.
Time was granted to my lordship to file the affidavit in reply. I require only 2 days time. It's absolutely ready. Certain papers are getting arranged, your lordship. Let it be on 16th.
16th, as paid
I
by
will pay for respondent, my lord.
Learned Council for the petitioner. This is an appeal.
In the last occasion, your lordship directed the respondent to take instruction as to why the
Lord,
copy was.
I've taken instruction, my lord. Valuation certificate has already been issued on 5th December 2024, my lord. This is the.
Hey, can you give him a copy? Have you given him a copy?
That's very good.
The parties are ad item.
Item number 9. Here are 56 of 2024.
Lordship, there are 3 set of revision application.
Three.
3 set of lordship. Item number 8, 9 and 10. Wherein the petitioner, the wife, has preferred
My
and
lord, I raised a preliminary objection in this case, lordship.
Regarding the
Kindly remember.
Regard,
regarding Family Courts Act, that appeal will lie before the division bench.
It is an order passed under section.
128, my lord, final order was passed.
The petitioner wife prepared in 128 Act.
Yes, you said you will assist.
Yes, yes,
regarding-
I'm ready. Lordship, my learned senior has raised an application regarding maintainability. He has pointed out 19 subclause 6, Lordship, the Family Court Act 1984, Lordship. Lordship, 19(6) says that an appeal preferred under subsection 1 shall be heard by a bench consisting of 2 or more judges. Lordship, first of all,
19 says
Lordship, Chapter 5, Appeals and Revision, 19 subclause 6.
6.
Yes, Lordship. This is the point my learned senior has raised before this honorable on the last date. Lordship, first of all, the instant petition before this Lordship, it is a revision. It's not an appeal. Lordship, now
read 5, then read 6.
Lordship, 19 subclause 2. Please, Lordship. No appeal shall lie from a decree or order passed by a family court with the consent of the parties from any order passed under section 9 of the Code of Criminal 1970. Lordship, kindly, section 9 talks
Chapter
about
9, not section 9.
no, sorry, Lordship. Chapter 9 talks about 125, 126, 127 and 128.
Yeah.
And this is a revision application which has come from an order of 128. That is chapter 9 of CRPC 1973. Now, Lordship, I will support my condition with 2 landmark judgments, Lordship. Lordship, this is the Lordship, this is the judgment of Karnataka High Court by Honorable Justice B. Padmaraj. Lordship, in this judgment, the Honorable Judge was pleased to answer 3 questions, Lordship. Lordship, and the one thing. Yes, sir. Lordship, in the Family Court Act, in the second page, Lordship, in revision, there is written where Family Court has decided application under section 125 CRPC, only revision is maintainable against such order. Asserting the judgment of Aruna Chaudhary versus Sudhakar Chaudhary. In the next page, Lordship. Lordship, I have preferred an application under 19(4), Lordship.
Yes.
Lordship, in this judgment,
which paragraph you are referring?
Lordship, in this page number 2,
Yes.
page number 2, point number 3, sub point number 3. In this, the Honorable Justice was pleased to ascertain this question, whether the matter has to be decided by single judge or divisional bench. After that, Lordship, page number 10, after going all through the matters, the Honorable Justice was pleased, page number 10, point number 20.
No, 1 is relevant, then comes 3. Where is the decision on 3-1, whether the revision petition has to be treated as number as civil or criminal law? That is not the issue arising.
Lordship, point number 3, Lordship. Point number 3.
What is the answer?
Yes, Lordship, page number 20, page number 10, point number 20.
Page number 10.
Page number 10, point number 20. Last page, Lordship. Herein, the answer is hence in our considered view, the revisional jurisdiction of Western in the High Court under section 19(4) of the Act is accessible by the learned single judge of this court. Lordship, there is another judgment, Lordship. I will cite, Lordship.
Yes.
Lordship, there is another judgment of.
Why you could not get any judgment of the Calcutta High Court?
Lordship, I found it from Indian Canon of Capital or not find. Lordship, this is also add to the point, Lordship.
You think that by now the Calcutta High Court would not have decided whether this is to be challenged in a revision or in appeal?
Lordship, kindly appreciate, Lordship. If argument say.
Why are you referring to judgments of another court without examining whether the Calcutta High Court has decided this issue or not?
Definitely, the Calcutta High Court have decided the issue, Lordship. Only one thing, Lordship.
Where is that decision?
If you Honorable Court please one more day, Lordship, I will place the judgment of Calcutta High Court.
Come on, come
Lordship,
on.
Lordship, also one thing, Lordship. Lordship, also one thing.
You have raised the objection. We expect you must be prepared.
No, whether Calcutta High Court pass any judgment.
You are raising objection without any.
I go with family court side.
All right, then we'll hear you. As paid by counsel for the petitioner, list on, give the date of Wednesday.
Grateful, Lord. Grateful.
It must be decided by this court. It appears it's either even under 482 it can be challenged. Why not?
Lordship, I can always challenge under
by criminal court.
and 227 of Constitution of India.
Finally disposed of.
What finally disposed of? The nature of order passed under chapter 9. It does not contemplate passing of a final order.
Grateful.
125, 126, 127, 128. The bar of 362 also does not apply because these are never final orders. They are subject to variation by the court. The statute itself gives the court the power to vary the order. So therefore, there is no question of final order. 2020 volume 13 SCC you examine. None of you have come with the judgment. 2020 volume 13 SCC page 172 if I am not mistaken. Sanjeev Kapoor versus somebody, I don't remember. And then you examine the Calcutta High Court judgment. There must be a Calcutta High Court judgment.
Item number 12. WPA 438 of 2024.
I am appearing for the respondent.
Yes, give.
My lord, in this case also, my lord, Vishal Kumar sir is appearing, my lord. Electricity matter, my lord. Vishal sir is appearing in this case, my lord. His health is not good, my lord. So I have prayed already I have prayed for next circuit.
No,
Few of them
you may prayed for the matter to be listed in the next week. On the last occasion.
No, my lord.
What? No. That is the order recorded in the order. How is it
Sorry,
saying
I
no?
think somebody else has maybe.
So therefore, every council will make a different pair.
No, actually, he's getting mumps, my lord. So
Can't be kept pending like this indefinitely. What is the issue?
But for grant of electric connection, they have filed this application.
Yes.
Since he is not in certain position, so we have not granted him the electricity connection.
There is an order of rejection. Is
No,
there a
rejection order is not there, Lordship, but we have communicated to him. He is praying, Lordship, let it be Wednesday or Thursday. Let his senior come and argue.
prayed?
his condition is not good, my lord. May not be possible to.
Then you have somebody has to argue. It can't be kept pending indefinitely like this.
Oblige, my lord.
Somebody will have to argue.
Let it fix on Friday, my lord.
Yes, as prayed, list on Thursday. Give the date of.
Obliged.
Item number 13.
I am appearing for the
Subject
respondent.
124.
Lordship, they have not served the copy. Though there is a direction by this honorable court, but they have not served the copy. Let it go to next circuit bench, Lordship. In the meantime, I will take instruction and come. Let them serve the copy.
How will you take instruction if they are not serving copy? They are not interested, let it be dismissed in default. Nobody is appearing.
Let it be not put day after tomorrow, Lordship.
None appears for the petitioner, full stop. There is no intimation to the
Same order.
14 same order. 13, 14 same order.
Same order, Mr. Park.
15. Who is appearing in
Item
15?
15.
They have not received the copy. Neither they have served the department.
Just filing matters to keep it pending.
No, Lordship, Arul Peter sir is appearing. He is unwell. He has reported me to place this matter in the next circuit. Lordship. He is-
No. Can't be adjourned for such a long time.
He has met with an accident.
Oh, it is that much.
Yes, Lordship.
Yes.
The learned advocate on record has met with an accident.
Item 16. WPA 1 of 135.
Lordship, my senior appears for the petitioner, Your Lordship. Service has not been affected, Your Lordship.
Can't be adjourned indefinitely. You give him a copy.
Lordship, I'm not having the brief at the moment.
Let a copy be served. Matter to be listed on Wednesday.
Obliged.
Obliged.
Served on Mr. So and so. Served on Mr. So.
Item number 17. WPA 300 of 131.
Item 17.
For respondent. Yes. Where is the file? Waiting for. From the order sheet, it is apparent that the petitioner has not been represented
Form of promotion.
In under which rule, which is the, which organization, what is the setup, what is the service rule?
The recruitment, they were, this person, my lord, was given the administrative responsibilities of welfare officer woman till finalization of recruitment rules.
Or till the finalization of recruitment rules.
Yes,
But the order says till regular appointment is made.
it will be after the recruitment rules. So that's why she's an ad hoc appointee, madam. And as per the latest, as per the proposed finalized recruitment rules, there is no post. So my lord, as on date, my lord, we have stated on affidavit that she is not working against that post.
Where is your affidavit?
Affidavit in opposition, my lord.
Where is that? In which paragraph?
My lord will see paragraph 13. And read with paragraph 16. Oh. Paragraph 16 also may be seen. Only for a period of 3 years, she was working on ad hoc basis because of the requirement. Hmm. Hmm. Yeah.
R by 3 is dated.
Draft recruitment rules, my lord, that is dated. Draft report. Date, my lord is asking. This is, my lord, dated 24th February 2022. Oh. Also, my lord, issue of locus standi is also there. It's not a PIL, my lord. And what capacity petition is filed?
PIL will not lie in a service matter. In respect of a service matter, PIL will not lie.
That's all. But this is filed as a PIL. The petition is filed like a PIL. Kindly see the first paragraph. The writ petition. Writ petition is law-abiding citizen. Writ petition is a right to information activist. And in the past, in order to espouse cause of public at large of these islands, instituted several proceedings without any vested interest. Even for instituting the present proceeding, there is no vested interest exist. Rather, illegal appointment conferred to the private respondent in the post of woman welfare officer is questioned. So he has no cause of action as such against the private respondent.
Yes, answer the issue of maintainability. And two issues are there. One is maintainability. And the next is now whether there is any issue left. Was only for 3 years and not continued,
Post
then
is a public servant office. Yeah. For that knowledge, that in the form of PIL must be accepted.
must be accepted. Show a judgment that a PIL can be filed in respect of a service dispute, service matter.
Sometime file.
Tomorrow?
Yeah.
Not today.
Item number 19.
Please come with the judgment.
Yes, madam. My learned friend point.
Both is-
Ayub Khan, Noor Khan.
Plus also the issue of raising seeking a remedy of co-warrant.
Co-warrant.
Whether
Item number 19, WPM 137 of 2020.
Lordship, I am for the petitioner, Lordship. Lordship, this instant writ petition was filed by Anando Haldarsla in the year 2020. I made my appearance in the year 2024. Lordship, order dated 4 October 2024 may be seen, Lordship. By Honorable Justice Ravi Krishna Kapoor, Lordship. Lordship, after this judgment, I have complied with the judgment. I have paid that rupees of 1 lakh, Lordship, before the municipal council, Lordship. Lordship, after that, they need to place before this honorable court the amount which is pending. Lordship, after this, what happened is the municipal council and the fruit vendor association, comprising of 32 people, are in talks, and there is a chances that they will settle the amount for the time of pandemic, COVID-19 pandemic. Lordship, the petitioner happens to be a 70-year-old person. I'm not able to get instruction where the talks are complete or not. Lordship, what I pray that this matter may be in the next cycle in the first day, so that at that time I can get some instructions.
no more pendency, sir. Enough is enough.
Lordship, kindly appreciate. I have made appearance in the
It's of 2020. It cannot be an endless.
Lordship, this matter was out of list.
Sorry, cannot be. You have paid. They are on talks. Once that happens, you will be at liberty to approach if it is not your liking.
Lordship, there is every chances this matter
Maybe. So we are
because they are
for that
considering the COVID
petition
time,
is,
Lordship.
for that writ petition is not to be kept pending.
Lordship, they are actually considering the time of COVID that they will leave the rent of the COVID, Lordship. Kindly appreciate the 3 years the petitioner having no business, Lordship. Also, he happens to be a senior citizen, Lordship.
That is not the point. The point is it cannot be for one person in the market. because he is a senior citizen. Whatever decision has to be taken uniform for all the vendors in the market. So therefore, the fact that he is a senior citizen does not inure to his benefit in the present facts and circumstances.
No, actually, in this
It's not an individual claim. It's a claim by all the persons will have to be dealt uniformly. It cannot be arbitrary that
No,
for one
Lordship.
person.
Lordship,
Yes, who is appearing? You are for the administration.
Lordship, one thing like to show, Lordship.
Okay.
Lordship, I'd like to show one thing, Lordship.
If something is pending, then we'll direct that. It will be final decision. Once it is taken, you can approach the courts.
It is Sakuri. Lordship, this is the Lordship. Why?
Sorry, no, nothing like that. Sorry, no.
Lordship,
There is a writ petition. In a writ petition, what is the relief that you are seeking? Let us see. Come to the prayer.
oh, Lordship, the petitioner happens to be a fruit vendor in the Mohanpura market.
Now, whether such a relief can be sought in a writ petition to reduce the rate of rent?
No, Lordship, I will
Come to your relief, sir.
Yes, Lord. Lordship,
To reduce the rate of rent.
no, Lordship.
For that, you have come to the writ court.
I will take Lordship 5 minutes, Lordship.
You take 10 minutes.
Yes,
Why 5?
Lordship, the petitioner is a fruit vendor who is selling.
He is fruit vendor, he is senior citizen. This you need not say.
He's
The
selling.
court is asking you whether a relief to reduce the rent can be maintainable by way of a writ petition. Come to that issue.
Yes, Lordship. Lordship, in this writ petition, there's an infringement of fundamental right under 14, 19, and 21. Because similarly placed pupils compared to the petitioner.
Who is that similarly placed?
Lordship, page number. Lordship, page number. Lordship, page number 25 of the writ petition, Lordship, annexure P5.
Come to the writ petition. Which person you are seeking parity with? Show from the writ petition.
So, Lordship, I am seeking parity with other shop vendors who are the tenant.
One person whose example you have given who is being charged a lesser rent than you for the same premises in the same market. Show it.
Lordship, page number 25.
Let him complete. Yes.
Lordship, page number 25.
No, you come to your averments in the writ petition. Who is that person?
They are the.
This is a writ proceeding.
Vegetable food.
You have to make a specific assertion. In view of that specific assertion, you have to corroborate by way of document. Where is the assertion regarding which person? Come to that person's.
Lordship, similarly placed, Lordship, are the vegetable vendors.
So one person from the writ petition by saying similarly placed 10 times, that will not improve your case. You don't need to show 100, just show one person. In the same market, having the same area, being charged lesser than you. Show. Yeah.
It is in page number 25, Lordship.
That's not the averments. Please don't try to unnecessary. Court is asking you a query. Answer that query, then you take to whichever page you want to take. Don't try to deflect the court's query or avoid it in this.
Yes. Lordship, page number 7 and 8, point number 11. In which the petitioner says that the Mohanpura vegetable market were similarly placed, having more the area and less rent, Lordship.
And you are in which market?
Same area, Lordship. They are having 9 square meter of shop, RCC shop with rolling shutter and everything. I am given 1 square meter of area in an open area, Lordship.
Just let me go. That is at page 25.
Yes, Lordship. Lordship, item number 20 and 22 are the similarly placed person, and item number 45 is the petitioner.
Item number 20 and
22, Lordship. Mohanpura Vegetable Market, 114 shop, Lordship. Their monthly rent is rupees 1000. Item number 22, Vegetable Complex, Mohanpura, 67 shops. Their rent is rupees 1000. Item number 41 is the food vendor who is having 1 square meter rent. His rent is rupees 50 per day. That comes around
item number
45, Lordship. Lordship, that comes around 1500 or 1550 plus GST, Lordship.
how do you say per day?
Lordship, page number 38. Lordship, it is one of the monthly rent, Lordship. First is the current tax 1660, areas and total rent.
How do you say 50 per day?
It's 50 per day, Lordship.
How do you say? From where do you say?
Lordship.
You have just shown page 25. You say that you are paying 50 per day.
Yes, Lordship.
And they are paying 1000 per month.
1000. Lordship, page number 18. Lordship, this is the receipt when the rent was rupees 20 per day. And this is the rent from January 2016 to June 2016.
That is all right. But you are saying the others are being charged 1000 per month. How can you say that? On what basis you are saying that? You are saying that on the basis of an extra P5.
Yes, Lordship.
So come to P5.
Yes, Lordship.
This is monthly rent.
No, Lordship. This is the if this is the monthly rent, I would never come before this honorable court, Lord.
Please try to understand what the court is saying. Have a look at P5. Don't be obsessed with what you are saying. Have a look, then you respond. You are saying that the person at serial 20 is paying 1000 per month. Now, the 1000 is mentioned in the last column. Whether it is per month or per day.
Per day, Lordship. Only for fruit vendors is per day. For every other person is per month.
So from where do we get this? Doesn't appear so. From P5, it does not appear like that.
Lordship, I have made representation also, Lordship. I will show, Lordship, page number 29. Where even I am saying
your representation will not suffice. It may be a self-serving statement. You are relying on P5, page 24.
Yes, Lordship.
It does not show that 1000 is per month and 50 is per day. It does not. From where do we gather that 1000 per month and 50 per day? You come to page 24. You read the top public notice. Revised market rent of shop kiosks, gumtis in municipal market. Now you read it. Revised market rent of the all these have been reduced across the municipal areas with effect from 16. However, thereafter many representations were received from various associations saying that the hike of the monthly rent was very steep. Monthly rent was very steep. The matter was considered by the council and it has resolved to reduce the revised market rent scattered across the area as under. Now all these are uniform. It does not say that for one it is per day and for one it is per month. Yes,
Vice details,
the stopwatch detail is available on the website.
revised monthly rent.
Yes.
Lordship, kindly appreciate
The
Lordship.
council has decided that monthly rent will no. It doesn't appear so. We don't know, I don't know from where you are making this submission. What is the basis?
Lordship,
There is no basis. You have just said something without any basis.
Lordship, my learned senior has been opposing me on this only. If she says it is not there, I will not trust my audit petition, Lordship. This is the case, Lordship, because I am the only person who is taken rupees 50 per day. Rest all petitioners are less than me and they are in monthly, Lordship. Their affidavit also says the same, Lordship.
Let us see where is their response to paragraph, where is your response to para 11 of the writ petition? You are appearing for the municipality. Show your response to para 11. Respond number?
2, 3 and 4.
Yes.
Denied in this it is further submitted that the number of vendors are regularly paying their rent as fixed by the Bombay Municipal Council. So I have annexed the list also.
Denied and disputed. There is no admission.
They are paying regularly and the
Yes.
writ petitioner.
No, but see, P5 does not contemplate, it's a monthly rent.
Lordship, if this is being advanced from my learned senior, then this writ petition may be disposed of that I am ready to pay rupees 50 per month for any time. Why?
Now enhanced to? Where is that enhancement? After 17, where is the enhancement?
Submitted one list. So, in that, what my lord has seen is in March 2017. It will automatically, it's 5%, it will enhance it. Is there?
Yes, that is there.
This 18% per annum of outstanding debt will be charged for late payment, which is already there. And you see, unless the terms and conditions of allotments provided, otherwise the due date for payment of monthly rent is 7 for daily interest 18% per annum. The council has decided that monthly rent will get automatically enhanced by 5% rounded off to next 10 rupees every year from 1st July onwards.
Yeah, that I have already seen. This is of 27 March 17.
The comparative statement of rent I have submitted,
Lordship, there is a comparative statement being of the rent. In this, the calculation is of per day. Submitted by respondent number 2, 3 and 4.
Comparative statement of rent.
Yes, Lordship.
Comparing with?
Monthly.
Lordship, there is a comparative statement of list of rents which is due being submitted by respondent number 2, 3 and 4. In this, the calculation also is
This is for the petitioner.
For the petitioner, Lordship. For the petitioner.
But how do you, what is P5? The mysterious document.
It's up to you.
It does not, it cannot be reconciled with this comparative statement.
Lordship, now 50 rupees per day is 1,500. From 1/2/2017 to 36/2017. 1 month, 50 rupees into 30 days. This is a statement given.
1/2/17 to 36.
36/2017 rent per month 1,500.
1/2. So February, March, April, May, June, 5 months.
5 months. 1,500 into 8,850 into 5 months is that calculation. You know, in the first column is rent per month. That is 1,500.
1,500.
Yes, let's see. This is the now what the learned council will say. You know.
So how can you, what is the rate being charged? It's so arbitrary.
1,500 per month.
How can you charge 1,500 per month? When it says 50, how can you charge 1,500 per month? And you don't deny it, you just say deny and dispute it. So what is the basis of charging 1,500 per month? You have given a comparative statement, but what have you said? What is the basis? Where is the agreement? Where is the order fixing it at 1,500 per month? If there is no order, then this demand is unsustainable. It's an arbitrary demand. You have put up tin sheds.
Yes, Lordship. No. I am in open space. There are other shop which we have complied our shop with polythene paper and bamboo syrup. With nothing, no current, nothing, your Lordship. We are sitting over an culvert, Lordship. This is a condition, Lordship.
Sitting over?
A drain, Lordship, a culvert. I'm not in any space, Lordship.
How can you sit on a drain? We cannot be permitted to sit on a drain.
No, sir, Lordship, this area was allotted with the municipal. They had made a slab over the drain and allotted me 1 square meter of area.
Where is the allotment? Show the allotment.
Lordship, annexure P2 and annexure P3, page number 20 and 22, Lordship. For the petitioner went before this honorable court, Lordship, High Court of 2015.
So you were having to pay 50 rupees per day.
per day. Lordship.
So after allotment in 16, that was the rate fixed.
Yes, Lordship. It was enhanced from rupees 20 per day to rupees.
Where
50
is
per
the 20 per day fixation?
Lordship, I have placed the receipts, Lordship.
I started paying since January 2016, I have annexed with my opposition. He has not paid anything before that.
I have paid, Lordship.
No.
At that time, there was no mechanism from the side of municipal. It was rupees 5, Lordship.
Where is the earliest fixation of rent that I'm trying to see? When, how do you say that you were ever required to pay rupees 20 per day? What is the basis?
Page number 18 in Lordship, Annexure P1.
It's 20 per day.
Where is that?
Annexure R1 page 8 of my opposition. Section filed by respondent number 2. It's written 20 rupees per day.
20 per day, yes.
2016, Lordship.
So you started paying 20 per day.
Yes, Lordship. After that, suddenly it was increased to rupees 50, apart from the GST, Lordship.
No, it was not really increased suddenly to 50. It was increased initially to 70.
After that objection,
Then it was rolled back to 50.
Yes, Lordship. And Lordship, one very barbarism thing had happened, Lordship.
No, but you have gone and taken an open space.
Which
You
I not-
wanted it. You applied for allowing for permission to sell in an open space above a drain.
No, Lordship.
Yes, that is your application.
No, Lordship. Actually, I was from 1993, I was fruit vending at there at rupees 5 per day. Subsequently, when the municipal told that they will going to extend the road, they said that you please vacate the place. After that, we will make you a fresh open shop. But they denied the same. And after that, I need to have my livelihood, Your Honor.
That is the background. But
Yes,
ultimately, you went to them that allow me to sell fruit from this drain on the top of this above this drain. They have accepted it. They accepted it and they wanted you to give 20 rupees per day. You started paying also. Nothing has been forced upon you. This you have asked for. Now they have revised the rent to 50, 70 and then rolled it back to 50. So what is the problem?
Lordship, kindly appreciate, Lordship.
How can you equate with someone who is in a shop, in a proper shop?
Lordship,
You cannot.
Lordship, kindly appreciate. From 1993, I am vending fruits.
No, that is over. That is over.
Lordship.
That is over the moment you got a fresh settlement, which is evident from your annexure 1.
Lordship, my settlement is comprised. They had to give me a shop which is a RCC shop with rolling shutter.
No.
For temporary junction, for temporary time, the allotment is area of 1 square meter. Kindly appreciate. I cannot close my shop. I need to earn my livelihood.
Come to annexure P2. This is annexed by you. You were given a choice to identify a suitable place. 4 locations were given to you. You identified this place that I want to sell it from here. They have accepted it. They have allowed you to sell from there. And now it is just an issue of some rent which they are charging.
Lordship, they identified me a place which is in the vicinity of the fruit vending. And my wish to they need to construct me a shop which is of a fully better, Lordship.
They do not. They do not. There is no such representation. There is by them in any document. Show from any document that they have said that they need to give you a RCC shop with a shutter. It starts with your order 6123 dated 3/11/2015. This records the entire thing that you have made an application for being allowed to sell fruit. They have given you 4 locations that you can go and identify either of these 4 locations. You say this is the suitable location for me on the drain. They say the drain is yet to be constructed. Once it is constructed, we'll allow you. Then the drain is constructed. Then an order is issued that the High Court says when you have said you will allow me, why are you not allowing? Then they allow you to sell from on top of the drain. They start charging 20 rupees. So finally you got what you wanted. Now it is just a question whether from 20 it has to go to 70, 50, 40 or 30. That is the only issue. There is no other issue. You come to page 20, 20, 21, 22. This is your documents. This is an arbitrary fixation. It cannot be justified by any stretch of imagination. How can you charge 1,500 from someone who you are not providing anything but a space and charge 1,000 per month from those who you are providing a shop? It is, all of them are there. It's not that somebody is at somewhere else. It is shocking to the court's conscience. So you ask who is the in charge of this body?
Actually, the chairperson.
No, there must be an executive. No, somebody above me. Who is it? Who? Secretary? You ask him to come out with some reasonable proposition, otherwise the court will pass orders. That's the only issue. We are not traversing on any issue beyond this, whether he is to be given a RCC or shutter. He says, I have got a space, you were not giving, so I have constructed a apartment, I am selling from there. Only the issue is rent. From 20 you jump to 50. What is the rationale? In 16 you fix 20 and in 17 you fix 50. And then you say 5% per month. So between 16 to 17, even if you were to jump to 10%, this is arbitrary. You please discuss it with this aspect and you come back tomorrow. You ask him. Take instructions. The
20, WPA 833 of 23.
My lord, I'm requesting for, not today, my lord, we have not been able to ascertain, my lord, the status regarding those.
All right,
regarding
not
those.
today.
My lord, if it's possible, let it be on Thursday.
Fine, Thursday.
Okay.
As jointly prayed, list on, give the date of Thursday.
Item number 21.
In this-
WPA 885 of 2023.
In this matter, this may be passed or to next circuit.
Why? What is the issue? Let us see.
Because I am not appearing, my junior is appearing and he is not well. Today in the morning only I got a call from him.
Let us see.
Because he prepares this, he has prepared this writ application. And file is with him only.
Oh, but on his prayer, it was adjourned to 13 January.
बारिश में भीगने की वजह से नहीं हुआ. Otherwise he would have come.
Cause notice is challenged and we have filed an affidavit placing on record that hearing was, all notices were given. The question is whether proceedings are pending before the estate officer under the Public Premises Occupation, Unlawful Occupation Act. Eviction or unlawful occupancy.
13th adjournment in a row is being sought for today. Yes, what is the issue?
My lord, the issue is, my lord, proceedings under the under the Public Premises Eviction or Unauthorized Occupants Act 1971, my lord, is pending with the estate officer.
So what is in challenge in the present?
We have challenged the show cause notices, etc., contending that no notice was received. So, my lord, we have, by way of our affidavit, my lord, given all the proof to show that notices were affixed, etc. And in any event, these contentions can be raised before the estate officer, my lord. There is a special forum for this. And the estate officer has to determine the question under section 5 of the Act. Once the decision is taken, it is then amenable to appeal before the district judge under section 7.
So why this has to be kept pending? The first order is also that it is subject to result of the writ petition.
Yes.
So there is nothing coming in your way. You have not proceeded.
That, my lord, I have to ascertain, my lord, whether they have proceeded or not.
Whether you proceeded or not, you can.
Usually they don't proceed when matter is pending in.
No, but there is specific order subject to result. It is not coming in your way.
I will ascertain, my lord, the status.
Tomorrow, come back tomorrow. We'll see. Not today.
I'll request him.
Sorry, can't be this 13 adjournments.
I'll request him. I don't know anything about it. Very honestly,
No, nobody appears, then it will be dismissed in default. Can't be like this. 13, 14 adjournment.
Item number 22. WPA 917 of 2023.
Item number 22 and 23, I am seeking for next circuit election.
Item?
22 and 23.
23 अब एक एक करके करिए ना. Respondent advocate से तो.
Yes, 22. Give the file. Petitioner is here. Petitioner is not appearing. You are for the petition.
I am for the petition.
Director of Transport.
Ji.
What is the issue?
Issue, my lord, there is a trade union. They have given a strike notice. And it is a public utility service. And after the notice of strike, conciliation started.
Conciliation.
Conciliation proceeding started.
Yes.
And during the conciliation during the pendency of the conciliation proceeding, they went on strike. Therefore, the strike was being illegal, everybody was suspended. 44% were suspended. And this was challenged. Ultimately, the labor court came to the finding that thereafter everybody was taken back on under one or the other plea. The only thing remains to be that during the period of suspension, they were not paid anything. They said they should also be paid that amount. We said that the strike was totally illegal, therefore they are not entitled. The labor court said that the strike was legal.
Legal.
Legal. Strike was legal, therefore they are entitled to payment. We said the strike was illegal on the face of it because it was a public utility service. It was in the first instance, the notice has to be given for 6 weeks. Here, the notice was given on 29th. That was a 14 days notice. And on 12th, conciliation started. And on 14th, they went on strike during the pendency of the conciliation proceedings. Once Section 20 of the Act says, once the notice is issued by the Labor Department, the conciliation, the commencement starts. And that was issued on 12 at page 40. And the tribunal says that there is no document produced. The document itself, the party, the respondent themselves has put their annexures. In that annexure, all those documents are there with all clarity that the conciliation proceeding started. And you have a look at the notice, my lord, first. That is at page 39, dated 2011-2018. And section 22 contemplates that the notice has to be given for 6 weeks. On the face of it, it is, and it was pointed out in the next page at 42, my lord, during the conciliation proceeding.
So where is the material to show that the conciliation was fixed on 12/12?
My lord,
That's the only issue.
my lord, they kindly come to their own what is called claim application before the labor court at page 109. It starts. Para 18, my lord. Conciliation was held on 14th of December.
Yes. No, the court wants to see any material where that it was on 12th, not 14th. If it was on 14th, then it will not be hit by 22.
My lord.
Only if it is on 12th, then
My
you,
lord. My lord.
14th they are admitted.
My lord. My lord.
14th they say that on the,
My lord.
the conciliation was fixed in the afternoon.
My lord, kindly page come to 119.
119. Yes.
It is a conciliation proceeding. It is annexed by the party themselves. As annexure. Annexure 3. This is annexed by them before the labor court. And this is referred to in para 22 of their own claim application.
But this is not of 12/12.
Your pardon, my lord.
This is for discussing the strike notice. This is not a conciliation proceeding.
This is conciliation proceeding.
No, it is not.
Kindly come.
It is not.
My lord, once notice under section 20 of the ID Act.
Yes.
Under section 20 of the ID Act, once a letter is received,
Yes.
that is P4
P4
at page 41. And 42, 41.
Give the ID Act. Page 41.
G. P4. It is a letter issued by the Labor Office, Assistant Labor Commissioner, that put the commencement of in motion as per 20, section 20 of the ID Act. Section 20 of the ID Act. Commencement and conclusion of the proceeding. A conciliation proceeding shall deemed to be have commenced on the date of which the notice of the strike of lockout under 22 is received by the conciliation officer. It was received by the conciliation officer. Thereafter, the conciliation officer issued a notice to the parties concerned. Therefore, Section 20 has come into motion. Therefore, the things have commenced.
Twenty has to be read with 22.
My lord, my lord. Well, and if my lord reads 22, my lord, on the face of the strike notice itself, it's illegal. Because it contemplates a strike notice of 6 weeks. And this present notice, which is at page 39, is a 14 days notice.
Page,
39, my lord.
so that is under 22, 2,
Can't be, my lord.
22, 2B,
My lord.
page 39.
My lord. On the face of the notice itself, it is illegal. And anything there consequent thereto illegal notice is also illegal.
No, no, this is the notice they had given.
Right.
So this is
Law contemplates the notice should be of 6 weeks. It is 14 days notice. And on the 14th day, they have gone on strike.
so 22 to 22 to B. C 22 to B.
Within 14 days, first condition has to be satisfied, the notice of the 6 weeks. And this is second. Firstly,
both have to be satisfied.
Pardon, my lord.
According to you, both have to be satisfied.
My lord.
Let us see. No person employed in a public utility service shall go on strike in breach of contract without giving to the employer notice of strike, as hereinafter provided.
First, within 30 days, giving such notice. If such notice is given, here such notice is not given. Such notice contemplates a notice of 6 weeks.
Not prior to 6 weeks.
My lord.
The strike notice cannot be more than 6 weeks old. Without giving employer notice of strike as hereinafter provided within 6 weeks. So it has to be within 6 weeks and within 14 days of giving such notice.
My lord.
So both are very well, it is complied with. It is within 6 weeks and it is within 14 days also.
My lord, the conciliation proceeding is started.
That is a, now, so therefore, what is the date of a starting of the conciliation?
This is, it commences
That
from
is
section 20, my lord. Once the notice is given,
Yes.
the notice is given on 12th and strike is on 14th.
Notice is given on
12th by the labor officer, conciliation officer, at page 40.
page 40.
It is as per section 20 of the IDA.
This is a how can it be? It cannot be. On 12/12 giving you are giving a notice that conciliation is fixed on 12.
My lord.
It is impossible.
What is section 20, my lord?
So this is whether this defeats, this just to defeat the statutory provision or to take undue advantage or to defeat the beneficial legislation. On 12/12 you give a notice that it is fixed on 12/12 at 10:45.
I have not given the notice. It is the notice of the labor commissioner on receipt of the strike notice. It is the reaction of the labor commissioner that they have received.
This is by the assistant director.
Jiji.
Again read P3. This is not by the labor commissioner.
It is by the labor commissioner, P4.
No,
at
no,
page
you,
41.
you said notice is dated 12/12.
My lord.
It is not 12/12 notice is issued by you. It is not issued by the commissioner, labor commissioner.
This is 10/12, my lord. Sorry, my lord. 41.
Oh,
41. 10/12.
this was issued by the LC.
G. And on the basis of we have.
So this was before the labor court.
G.
From where?
It is the labor code that had issued notice to all of us, to both of us, both the parties. Having received the strike notice, it is the reaction of the labor court intimating both the parties that the proceeding will take place on such and such date, on 10th. So the commencement has started. And it is their own document they have annexed.
And it did not conclude on 14th.
My lord. Yes, it did not conclude. Okay. It continued. My lord, says page 42.
32.
42. Immediately after that notice, that is 41, there are 42 is the proceeding, my lord, attended by the according
That's what I have just gone through the entire proceeding.
my lord.
12, 13, 14, all
My lord.
3 days. And the next date was also fixed. How do you justify your action? No, no. Sorry. Let him come. Can't be, these matters cannot be cut. Then you argue, we'll hear you.
If it be on Friday, I'll take instruction.
Yes. As paid by land council for the respondent.
People.
Item 23, WPN 1924.
Senior petitioner in this matter. This also I'm praying for next circuit election.
What is this? All the matters you are praying for adjournment, why?
He's not available in the station.
What is this? How the court will function if he is not available, then the court should shut down. Very
That's a
unique player.
personal difficulty as if he left to Mumbai.
Series of adjournments, every date adjournment. Next circuit. Adjournment on behalf of the petitioner. None appears. Second December adjourned. So IOC has filed the opposition.
My senior appears on behalf of the IOC.
When did you file it? And you have deposited the cost. You are for the IOC.
Senior is for the IOC, Your Lordship. I need to take instruction from my senior.
Tomorrow, come tomorrow. Inform the court whether you have deposited the amount or not.
Let it be in the next circuit, then, Your Lordship.
Let us see what she comes back with. Not today.
Item number 23, sorry, item number 24, WPA triple one of 2024.
This matter, my senior is appearing for the writ petition.
Your Lordship, in this particular matter, I appear behalf of the private respondent number 4 and 5. Require time to file AO, Your Lordship.
Time to file?
AO. Opposition, Your Honor.
They have to send an invitation to you. Last day you were not here.
We were there in the court number 2, Your Lordship.
So nobody should be here. For AO, you have been taking time since September. The first order is of September 30th. Time to file AO. And then also it was extended, so there is an earlier order. How long does it take to file an AO? From July 31, you are filing AO.
Your Lordship. Just 1 week, Your Lordship. Just
by way of last indulgence for filing AO on behalf of the private. AO.
Obliged.
Item 25, WPA 339 of 2024.
Item 25, my lord, can it fix on Friday, my lord? It's fine. The arguing counsel is in Terence decrease is it will unwell, my lord.
I think the exchange of affidavits has been
Yes,
done.
affidavit in opposition has been filed.
Reply also.
Reply, I don't have a copy, but maybe it is. I think he has submitted reply here.
Also, it is submitted that as prayed by learned counsel for the petitioner.
Yeah.
Item 26.
I am for the petitioner.
My lord, I am for the private respondent. My lord, my learned junior is there. this matter was brought on the file, my lord, in the list, my lord, without informing us. Number one, we have already filed an appeal, my lord. We have filed an appeal. The appeal numbers your lordship will get. My learned junior will hand over to your lordship. Unnecessarily, this has been brought in the list when the appeals are pending. We have filed 2 appeals, my lord.
My lord, 18 November order may be seen. The encroached government revenue land belonging to the Port Blair Municipal Council as well as revenue, constructed hotel.
Which order is under challenge?
Both the orders, my lord. Both the orders. The first order and the second order, my lord.
Just wait. Yes, which orders are under challenge?
Orders are not under challenge, my lord.
What are you, what
I
is the?
filed before this court, my lord, for the page number 11 may be seen, my lord.
What is the relief? Come to the
My
relief.
lord, yes. Page 7.
So you are claiming encroachment at the hands of the private respondent.
No, government land was encroached by the private respondent. I lodged a complaint. On my complaint, there was a report. Report is appearing at page 18.
Very well, you mentioned without intimation, let him.
Already this affidavit direction
will
was
come.
given on 18th November.
It is submitted by Mr. Samantha that the matter was listed without intimation.
No, thereafter I
To stop.
intimated.
And we have filed appeal, my lord. 2 appeals are there, my lord.
Appeal.
The matter is therefore adjourned. Thursday, you make your submission, what appeal, whatever you filed, we'll see.
My lord, mat number is given. My learned junior is there, my lord. He'll hand over the slip. Both
Thursday.
are under challenge, my lord.
Yes.
Obliged, my lord. Obliged.
Item 27,
I'm grateful, my lord.
123.
I am appealing for the appellant, my lordship. There is a direction to prepare the paper book that was already prepared. And for the respondent, I am not able to serve. So I issued a notice, my lordship, on Saturday. It was speed post done, my lordship. So need some time, my lordship, so that I can take the track report.
So from 23, you have not served. 2023.
Meantime, my lordship, paper book was prepared, my lordship. Meantime. That was
Yes,
a copy
keep
of the
the file.
paper book of the respondent is also lying in the record itself. Initially admitted, my lordship, thereafter paper book direction was there. So some delay was there to prepare paper book. Now the paper book's ready.
Some delay. From 17 August 23,
Yes.
it was admitted.
Yes. Thereafter paper book direction was there, my lordship. So paper book was prepared. And copy of the paper book in respect of respondent is lying in the record, my lordship. Once he is coming after receiving the notice, then I will hand over this copy to him. Let the registry may be direct, my lordship. It's a copy of.
File your affidavit of service.
Yes, my lordship.
Let the affidavit of service be filed. Give the
Problem, keep your lordship.
Item number 28, SCT 3 of 2024.
This matter will not today because paper books are prepared.
not today.
Alright.